Good afternoon, everyone. My name is Mark Carter, and I'm the Wilma Mankeller Legal Fellow at the National Congress of American Indians. I will be your host and moderator for today's webinar. On behalf of the National Congress of American Indians, I'd like to thank you for attending this presentation on tribal land leasing, opportunities presented by the HEARTH Act and the newly amended 162 leasing regulations. Before we begin the presentation, I'd first like to go over some of our features. You should see on your screen the PowerPoint for today's presentation. If during the presentation you experience any lag in slide transition, it may be as a result of internet connections, so just give it a few extra seconds to update on your screen. To ensure a distraction-free environment for our panelists, all audience phone lines will be muted throughout the presentation. If you would like to ask a question, however, then please type your query into the questions box on your webinar control panel. After the presentation, we will have a question and answer session in which panelists will answer questions submitted through the questions box. Finally, this webinar is being recorded so that you, as well as others who are not able to attend today's live session, will be able to access the presentation at a later date. Now that we've covered some of the webinar features, I'd like to introduce today's panelists and give a broad overview of today's presentation. Our panelists today are Karis Begay, attorney at the Navajo Nation Department of Justice, and Matthew C. Kirkland, Chief of the Division of Real Estate Services at the U.S. Department of Interior's Bureau of Indian Affairs. Today's webinar will give an overview of tribal land leasing through two separate processes. The first that we will cover is the process recently made available to tribes through the passage of the Helping Expedite and Advance Responsible Tribal Homeownership Act of 2012, or the HEARTH Act. The HEARTH Act allows tribes to draft their own leasing regulations, and upon approval by the Secretary of Interior, allows tribes to approve leases of tribal trust lands subject to tribal leasing regulations. Karis will give some insight into the Navajo Nation's process of drafting and implementing its own leasing regulations, highlighting key elements that tribes may want to consider when seeking to take advantage of new opportunities presented by the HEARTH Act. The second tribal land leasing process that will be covered today is through the newly amended Title 25 of the Code of Federal Regulations, Part 162, and through which each lease of tribal trust land must be approved by the Secretary of the Interior. Matthew will take us through some of the important changes that have been made as a result of these amendments. So without further ado, I will now turn it over to Karis to begin the presentation. Karis, the mic is yours.
Thank you. When the HEARTH Act was passed, it was an amendment that was made to the Navajo Nation Land Leasing Act of 2000 that was passed back in 2000. And this was something that the Navajo Nation was pursuing in the early 90s and through the 90s. And the objective for seeking this amendment to the federal statute was really for economic development purposes. But we expanded the language to include all type of leasing except mineral leasing. And the public law that was passed back in 2000, which has been codified now at 25 U.S.C. 415E, it basically allowed, had three main requirements, which is that the Secretary didn't have to approve our leases if we had tribal regulations, and if the term of the lease was limited to 25 years with two options to renew 25 years for a lease up to 75 years, which is important to know because it's a little bit different than under 415A, which is what tribes utilize to issue their own leases, and that is set at a 99-year term. So the term under these regulations are a little bit different. And the last part of this was that there had to be some kind of environmental review, and it wasn't really tied to NEPA process. It was very loose language. It just said some kind of environmental review had to be conducted. And so those are the three basic requirements in the federal statute that was made under the Navajo Nation Land Leasing Act. So when we had this passed back in 2000, it was signed by former President Bill Clinton. The Navajo Nation, we created a task force, and because the tribal regulations is really what we needed to create first. So we established a task force that created from different members, business owners to tribal leaders to attorneys, members of our Division of Economic Development and Division of Natural Resources sat on this task force and took a number of years and a number of drafts before it was finally completed. We also decided it was important because this was something that was going to impact across the Navajo Nation in many many interest, we decided to conduct public hearings and allow for public comment on the regulations. And so we began that process back in 2002. And after incorporating the various concerns of the communities and really what goals they wanted us to achieve in pursuing these regulations, we finally presented those regulations to our Nomination Council in 2005. And on August 1st, 2005, the Navajo Nation, we made our submission of our Navajo Nation Business Leasing Regulations of 2005 to the Secretary. And we actually had it done in what we call a joint letter, which was signed by the President, Nomination President, our Nomination Speaker, and also our Chief Justice of our Supreme Court. And so we made that submission in August, and we finally received a response from the Bureau of Indian Affairs, which is on the next slide, on January 5th, 2006. And when we received the response, it was, there was a lot of questions from the BIA, primarily asking for more information sort of on the review process, and a lot of issues started arising as to what role the BIA was going to be playing in this process. And they submitted a rebuttal draft to the Navajo Nation, and while they didn't place themselves in the approval authority of the business leasing process, what they ended up doing is putting themselves back into all of the review process. And we, of course, the Navajo Nation had raised a lot of objections to that. We didn't think that that really fulfilled the intent of the Act. And on the next slide, there were really two issues that we had with the Bureau of Indian Affairs. The first one was having a better understanding of what the word consistent meant. There was a disagreement between the Navajo Nation and the BIA that whether consistent means an reinsertion of the BIA process back into this, meaning they wanted to reinsert themselves as part of the review process. But we took the position, a strong position, that when Congress passed this, the intent of the statute was that it was supposed to give autonomy to the tribes, for them to have this ability to issue leases without any involvement of the Secretary, that it was supposed to streamline the process, that it was supposed to empower the tribes, and that was really an intent. And by placing the BIA back into the process really defeated that purpose. The second part, or the second issue we had, which we sort of understood, was the BIA did not know how it was going to maintain its trust responsibility to the tribes unless it was part of the review process, and unless it had some kind of monitoring or oversight into the review process. But the Navajo Nation, we disagreed with that. We felt that that when Congress put certain safeguards into the federal statute by saying that there should be it should be consistent, or the tribal regulations need to be consistent with the federal regulations, and putting in some kind of environmental review process, those were safeguards that Congress had inserted in there, and with the intention of streamlining it, that the real intent of this act was that the Navajo Nation would be able to carry out its own leasing process without any involvement of the BIA in the review process, and certainly in the approval process. It was pretty clear that the Navajo Nation was given that authority. So what we did from that point, we had several meetings over probably about 4 or 5 months. We weren't able to come to any real consensus on what consistent meant and how to maintain the trust responsibility with the regional office here. And on the next slide, the Navajo Nation, we actually redrafted the regulations using the regulations that was given to us by the Bureau of Indian Affairs. And in that rebuttal draft that the Navajo Nation submitted, we took out all of the references to the BIA and to the Office of Special Trustee. And we actually made this submission back to the Assistant Secretary in D.C. and met with his office and met with his staff, and basically explained what we, the Navajo Nation, felt this Navajo Nation Land Leasing Act meant, that the Navajo Nation was given the authority to have full autonomy over leasing on the Navajo Nation, and to streamline that process and to have the sort of the management authority of these leases, and including the approval authority. And a few days later, after some discussion with the Assistant Secretary, on July 10th, we made a final submission to the Assistant Secretary and told him, this is what we feel serves the interests of the Navajo Nation. And on July 10th, he agreed. They agreed that the intent of the statute was to give tribes, or to the Navajo Nation, full autonomy, management, approval, execution authority, all authority to the Navajo Nation to be able to issue its own leases. And on that same day that determination was made, the regulations were signed by the Navajo Nation President and by the Assistant Secretary of the Interior. And we were able to start issuing our own leases from that point. One of the requirements while we were sort of in negotiations with BIA was there was a concern about understanding what the management sort of process of the leasing, meaning from the moment that someone puts in an application for a business site lease, and what happens over during that time, the negotiations part, what are the requirements to get a lease, all of sort of the policy, technical issues. We decided that, and that was really the concern that BIA had. They wanted to know, kind of have an insight into what that process would look like, because the regulations aren't specific to that. So in our regulations, in the Navajo Nation regulations in Section 401, we actually agreed to establish what we call a business site lease management plan. And that management plan actually outlines all of that process, sort of how to get a business site lease, how to do modifications, how to get a sublease, how to get permits, and then the monitoring and the enforcement part of it, which is the compliance of the lease, ensuring that there's a constant review of the leases to ensure people are paying their lease rental and they're operating within the purposes of the lease. So we created this management plan, which we agreed to implement before we issued our first business site lease. That was sort of part of the negotiations that we agreed to do with the BIA. So after the regulations were signed, we spent many months putting that management plan together. And on the next slide, after we got that approved, we had to create a new standard form business site lease. We had to create new standard forms for everything because now we had removed the secretary from these leases, and we had to bring them in accordance with our new regulations and with our new policies. On March 1st, 2007, the Navajo Nation issued our very first business site lease. And on the same day, which I'll explain more what transferring is, we also had the first BIA approved lease transferred to the governing authority of the Navajo Nation. And since then, to date, we've issued over 100 leases across the Navajo Nation. We now have about 400 leases, business site leases, and we've transferred around 200 BIA leases to the governing authority of the Navajo Nation. So we've been working really diligently with our businesses to get them under this new process of the Navajo Nation. So essentially that's sort of what the Navajo Nation went through in getting these regulations implemented and getting our program going. And just recently, the HEARTH Act has come and amended the Navajo Nation Leasing Act and is now known as the HEARTH Act. And it essentially is granting tribes the same authority that the Navajo Nation has been exercising since 2006. So what the HEARTH Act really does, on the next slide, it allows tribes to issue leases, whether it's business site leases or home site leases, on its own tribal lands in accordance with regulations, tribal regulations. And the Navajo, one thing that I want to emphasize about these regulations is that when we were establishing them, in the business industry, commercial industry, there has to be quite a bit of flexibility. And one of the issues we were having under the Bureau of Indian Affairs was there was this strict set of requirements. And it made it difficult to have flexibility with different businesses because one size doesn't fit, one shoe doesn't fit all. So it was important when we were establishing these regulations that we allow for this flexibility to be tied into commercial and industry standards. So we built into our regulations a lot of waivers, exceptions. For example, in our appraisal section, we've been able to establish an equivalent system that we don't have to really do appraisals, but we created a market data study that has done an economic analysis across the entire Navajo Nation. And so we don't issue appraisals anymore. We now go into this market data study and are able to determine, based on various factors, how much these businesses should be charging across the nation. And it saved us a lot of time and a lot of money being able to create this new study. And so in our regulations, if you'll see that we've actually added language in there that, in determining the fair market value for lease rentals for these businesses, you can, follow the fair market value using an appraisal, or you can also do an equivalent procedure. So we've inserted different exceptions and equivalents, use a lot of equivalent language to be able to give us flexibility in our management plan, which is really the policies of the regulations, to be able to accommodate the different types of businesses that come onto the Navajo Nation. Because we have businesses that come in that are industry businesses, manufacturing plants, energy projects, and then we have, the mom and pop stores, restaurants, small-time businesses on the Navajo Nation. So we wanted to make sure we had these exceptions and waivers and equivalent procedures that could fit all the different types of businesses that come onto the Navajo Nation. So it's important when you're developing these regulations for your tribes to make sure that you create them in a manner that you can accommodate everyone from manufacturing plants to even non-commercial facilities. We're able to issue our leases for some nonprofit organizations. And so these regulations really have to fit a variety of type of people or industries and businesses coming onto your tribe, into your tribe land. So the requirements in the Act, it only applies to Navajo or to tribal trust lands, and it doesn't apply to any lands held in trust for individual landowners. But the requirements, on the next slide, the requirements of the HEARTH Act is once you've established these tribal leasing regulations and sent it through whatever your tribal approval process is going to be, once you make that submission, the Secretary has 120 days to review it. It does have to be consistent with the new with the federal regulations, and there has to be some kind of environmental review process. In the Navajo Nation, we created our environmental review process that is quite extensive, and we've had to establish offices and departments to be able to carry out that authority. But the environmental review process, NEPA doesn't apply. And because of that, you're able to be a little, to create an environmental review process that that really meets your tribe's needs. And so and tribes can define the word public. And Matthew, I don't know if you want to add some more information on this environmental review.
I do, and thank you, Karis. This has been one of the interesting points where tribes can define public. I think the trend has been for those tribes that have submitted under the HEARTH Act is to kind of expand the definition of public, and as a representative of the Assistant Secretary's Office here in Trust Services, we encourage tribes to really give some thought as to what they're going to deem the public to be. So it could be the general public at large, or it could be tribal members, or it could be as a very narrow definition, meaning tribal members that are affected by the proposed project. So I just wanted to emphasize that point, that tribes do have a lot of latitude in how they define public under the HEARTH Act. Thanks, Karis.
Sure. So going on to the next slide, whenever we were developing the regulations, and as I was mentioning, one of the biggest difficulties we had in our negotiations with the BIA was trying to determine what the word consistent meant. And so these are some of the areas on the slide that shows sort of the basic technical requirements that that we feel were consistent with the federal regulations, such as the legal survey. And the legal survey, the reason why, and I'll add on to it a little bit later, which is we still have to record these leases in the Land Title Records Office with the Department of Interior. So part of that recording, the main part of that recording is the legal survey and the land description. So we do still have to follow the federal requirements for conducting land surveys. Insurance requirements, recording, and as I mentioned, recording, we still have to record these at the LTRO. Determining what kind of annual lease, monthly lease rental that you're going to be charging to on these leases. And then sort of addressing these other different transactions like subleases, assignments, modifications. And so this is what we came up with as what would be consistent and what needs to be addressed in your federal or in your tribal regulations. But again, it's good to try and create these exceptions and try to, really ensure that these different technical requirements are tied into more of a commercial standard versus trying to be specific. Because you'll find that, in the business world, and things change quite frequently. So it's good to try and tie in these requirements to what the commercial industry standards are. On the next slide. This was something that was debated quite a bit as to what an environmental, and this is probably the big and most difficult part of these regulations and implementing these regulations that you'll probably face, which is the environmental review. And it was determined that there's no federal action in issuing these leases. There's no involvement of the federal government in this, and so it was determined that NEPA doesn't apply. And so the Navajo Nation, we created an internal environmental review process, and our laws are already pretty well developed in this area, and so there wasn't a lot of changes that we had to make internally. We have our Navajo Environmental Protection Agency and our Navajo Division of Natural Resources, and we ended up creating an additional office within the Navajo Nation called the Office of Environmental Review. And so we've put in these technical individuals that are able to carry out the environmental review process for the Navajo Nation. And we actually created, since FONSIs are no longer issued, we created environmental review forms, and we've created an environmental review summary form, which now serves as comparable to what a FONSI would be. And so those are each issued for each lease as determining that it's completed the environmental review process through the Navajo Nation. And our environmental review process, on the next slide, is really just clearances that we receive from our 3 departments, which is our Historic Preservation Department, EPA, and our Fish and Wildlife Department. So those 3 departments conduct the environmental review for our leases, and once they complete it, then an environmental summary is issued by our Office of Environmental Review that it's been done. So that's sort of how the Navajo Nation has established this, and we've established the process. It's a little more extensive in our regulations, what these different departments have to do, and in coordination with Navajo Nation law as well. But the thing that we've enjoyed about the environmental review is that because it's all within the internal Navajo Nation, we've been able to do this without having to really, well, it's an internal process now. We don't really go out and contract anymore, and so it's been a lot of cost savings, and it's been a lot quicker now that we have an Office of Environmental Review that just does this on a daily basis. Our environmental review process has really been expedited to a really short time frame, and I think it's like 20 to 30 days, and we're able to complete this process. So it's really been, we've seen a lot of benefit of having created this internal environmental review. So on the next slide. One thing I wanted to, I know Matthew talked a little bit about the environmental review process, but one thing I want to emphasize to the group is that one of the changes, a major change in this act is the term of the business site lease, or the lease, I'm sorry. We're going now from a 99-year lease to now a shorter lease, which is 75 years, but it's broken up into increments of 25 years each. And so we haven't had a lot of issues with that. There's been some concerns about the financing part of it. People want a little bit longer, 30, 50 years for longer investments. But for the most part, because of the other aspects of our leasing program that people find quite beneficial, especially the environmental review process, the 25-year term hasn't been much of an issue for many businesses. But it does affect the ability to transfer leases to the governing authority of the Navajo Nation. A lot of the leases that were issued under the BIA were 30-year leases. And so those leases that are beyond the 25-year term cannot be transferred to the governing authority of the Navajo Nation because it extends beyond the 25-year term. But what we've been finding is that businesses have been open to reducing their term to a 25-year term to be then taken under the Navajo Nation's governing authority. So those are some issues that the term of the leases, the limitation, might impact your leasing program. But we have found that a lot of businesses have been open to wanting to be under the Navajo Nation because of the benefits and the flexibility that we have. And so we've had a lot of people constantly requesting to transfer to the Navajo Nation. But again, it all comes to how you set up your leasing program, making sure that it's flexible and providing, showing indication that it's more, the time is a lot quicker. So that's really important to businesses. The economy and the market can change over a month-long period, and if you can produce within that time period, businesses are more open to wanting to come and participate under your program. On the next slide, there is still a partial involvement of the Bureau of Indian Affairs that we still work with their offices, and that is the encoding and recording of leases. And so under the Cobell lawsuit, the BIA had to create a system called the Trust Assets Accounting Management System, which is a TAM system. And all leases and encumbrances across Indian lands are put into this system. And what the Navajo Nation did is the BIA is the one that's responsible to encode, and once it's encoded, then it's sent to the Land Titles Records Office for final recording. And so what the Navajo Nation, what we've done is we've actually entered into an agreement with BIA on continuing that service of encoding our leases for us that are issued because we don't have access to that system. However, after we took over the leasing, we had learned that we were able to have someone certified to go in there and be able to encode for the Navajo Nation. So we had one of our, we created a real estate department. That real estate department underwent the training, and I think there's an extensive background check and different requirements that had to be satisfied to get this person certified so that they could encode and access the TAM system, and that really brought everything under the Navajo Nation's umbrella. But the only part that we aren't responsible for and can't do, I guess, is the recording part. And so we still have to send that, on the next slide, we still have to send that lease to the Land Titles Records Office for final recording. And that's really necessary, especially for business site leases, because that's what the financial institutions want to see. So that step is still in there that we still have to work. But the only stepping stone is really the encoding part into the TAM system. And so if you want to take on the full authority, that's something that you can work out with your local regional office to get someone certified that can access that system. So anyway, that's the end of my part of the presentation. So I'll turn it back over to Mark.
All right. Thank you, Karis. Really appreciate your presentation. Really great information. And now to talk more about the newly amended 162 regulations, I'll throw it over to Matthew.
Hi, this is Matthew Kirkland. I'm the Division Chief for Real Estate Services with the Bureau of Indian Affairs, and thank you for inviting me to the presentation today. And thank you, Karis and the Navajo Nation, for really being the trailblazer on laying the groundwork for the HEARTH Act. I'm going to kind of extend on Karis's discussion and talk about HEARTH Act, and then we'll talk about the 162 regulations. The process for now is that the review of the tribal leasing regulations occurs here in central office. So when they talk about approval by the secretary as a practical matter, that means that It's the Division of Real Estate Services in collaboration with the Office of the Solicitor. We will review, typically in draft form, proposed regulations from the respective tribes. Right now, we have approved regulations for the Federated Indians of Great Rancheria. That was approved on February 1st of 2013, and then the Pueblo of Sandia was approved March 14th, 2013. And both of those regulations were approved. They came in draft form and were approved within the 120-day timeline. Currently, we are working on Pokagon Band of Potawatomi. We received that document on December 18th, and we're near completion, working with the tribe and getting the approval. And then we just received Citizens Potawatomi Nation on March 19th. So we're gaining experience as we move through the process. But as I said, for now, the review is here in central office. We have published national policy that lists criteria in determining whether the proposed tribal regulations are consistent with 25 CFR. What our intention is to leave the review here in central office for approximately 1 year. Once we have gained some experience in reviewing the regulations, our intention is to move that down to the regional level. As a practical matter, the review process includes, we notify the respective regions to let them know that a tribe in their region has submitted a proposed leasing regulation under the HEARTH Act. On the next slide, if a tribe is interested in moving forward with their own leasing regulations under the HEARTH Act, there's a couple of options. You can contact your regional realty officer, or you can contact me here in central office, and you've got my phone number and email address. And at this point, the process is collaborative. So generally, what we do is begin a discussion with the tribe, or their what's typically occurring is the tribe's legal representative will give us a call and say, you know, the tribe is interested in submitting regulations. We'll get a draft. We'll go through a couple of different versions. Typically, after we receive the first draft, we'll meet internally, put our comments together, and then we'll meet back about 2 weeks later with the tribe and their representatives and let them know what our recommended versus required changes are to the proposed regulations. So again, it's a fairly informal process at this point. It seems to be working well. So what I want to share is a couple recommendations on lessons learned as we've reviewed the first 4 that have come in under the HEARTH Act. In the proposed regulations, we encourage tribes to be consistent with Part 162. And that's not to say that the tribal leasing regulations need to be an exact duplicate of 25 CFR Part 162, but where a tribe elects to put language in their leasing regulations, we encourage them to be consistent with our regulations. We also encourage tribes to collaborate with BIA Realty here in central office in reviewing that first draft. We will start the 120-day timeline upon the first submission, and we do send out a letter indicating what the beginning date and ending date of the 120-day timeline, and we've been pretty good. We've met those timelines for each submission, but it really is part of that collaborative process, working with the tribe and their representatives and staff here in central office. One of the other recommendations is to be certain not to include tribal approval of individually allotted lands. Of the submissions that we've received, this is one of the areas where we noticed that many tribes had included tribal approval of individually allotted lands. Let's go to the next slide. When you're submitting the regulations, it's important to address them, and I believe this is in the HEARTH Act or in the Federal Register itself. The proposed regulation should be submitted to the Deputy Bureau Director of Trust Services. It then moves over to the Division of Real Estate Services. So we provided the address for the formal submission of the proposed regulation. So that's the HEARTH Act. What I want to do is talk about another emerging issue in real estate services, which is 25 CFR on the next slide, or on this slide. As you know, 25 CFR Part 162 is the tribal lease, or the federal regulations on leasing Indian lands, and it went through a consultation over the last few years, and we've redrafted, and the final rule was published on December 5th in 2012, and the new leasing regulations became effective January 4th, 2013. And the new leasing regs have some significant changes, as we show on the next page. And I'm not going to read through each item, but on the next slide, you'll see that the new leasing regulations do modify. They're a significant shift from the old leasing regulations. So we replaced Subpart F, which were non-agricultural leases, with a new Subpart C, residential, Subpart D, which is new business leasing. For those that you out on the line that do business leases, you may recall that business leasing had been reserved for several years. We've also added Subpart E, which are wind and solar resource leases, and then also wind energy evaluation leases. And then we've added Subpart G, which is records. We've included agricultural leases, which have not changed. And then Subpart E was moved to Subpart F. So those are some of the changes under the new regulations. Let's take a look at the next slide. So I want to talk about each of the subparts. Residential leasing applies to leases for housing purposes or construction of single-family homes or housing for public purposes. The business subpart applies to business leases for religious, educational, recreational, cultural, or other purposes, leases for commercial or industrial purposes, and service leases not covered by other subparts. Wind and solar energy leases, which are new. We have the wind energy evaluation lease, which is in effect a short-term lease that allows a tribe or individual Indian landowner to enter into a lease to evaluate the feasibility of having an energy wind energy project on their land. Let's go to the next slide. Historically, the Bureau of Indian Affairs had approved permits. Under the new leasing regulations, the landowners may issue permits for use of Indian land without BIA approval. That's a significant shift from past practices. The thought was that a permit is not an encumbrance on the land, but a limited use or access to the land. Therefore, the Bureau of Indian Affairs didn't really have the authority to approve permits. So given that we're no longer approving permits, we're also not enforcing or administering permits on Indian land, and the exception is for agriculture. The permitting rules are still in place for agricultural leasing. We do state in the new regulations that the permitting activities must comply with all applicable environmental and cultural resource laws. And I believe in the new regulations that a copy of the permit is required to go to the local agency for review to determine whether it is in fact a permit versus a lease. Let's go to the next slide. So under the new 162 regulations, one of the questions that came up through this and similar presentations, when do the lease documents, when do the new regulations apply under lease documents? So if the lease document was submitted for approval after January 4th, 2013, the new regulations would apply. If the lease document was submitted before January 4th, 2013, and BIA approved it before January 4th, 2013, then the prior regulations apply to that lease. So again, the new regulations do not necessarily apply to existing leases. It's for leases moving leases in effect after the approval date. Let's go to the next slide. In this area, we want to talk a little bit about taxation. As we know, many localities have imposed taxes on improvements on Indian lands, and the Secretary and the Solicitor's Office wanted to make an affirmative statement on behalf of the Department with regard to taxation. And so under the new regulations, we stated that permanent improvements on leased land, activities conducted under a lease, and the leasehold or possessory interests may not be taxed by state or local governments, but may be taxed by tribes. And what we've learned in Pacific region out in California, we've already had 2 tribes in the Pacific region that have taken this provision in the new leasing regulations and have began to develop their own tax codes to determine how they might step into a role of taxation that might have historically been filled by a local government. So this is a significant statement in the new leasing regulations. We're not at liberty to give any tax advice, but if this does affect one of the tribes, we would encourage you to talk to your in-house or outside counsel about the impact of this affirmative statement with regard to taxation. We also added in employment preferences. We state that leases may require the lessee to give a preference to qualified tribal members based on their political affiliation with the tribe. That's a shift from a typical employment preference or tribal employment preference. It gives specific preference to tribal members, or it gives the tribes the ability to give preference to their tribal members. So again, it does not have the general Indian preference. Let's go to the next slide. So we want to talk about who must obtain a lease. So anybody who is not the landowner must obtain a lease. A tribal housing authority, if it is a legal entity independent from the tribe, regardless of whether it is owned and operated by the tribe. And then a tribal housing authority does not need an approved residential lease if the tribe has authorized the tribal housing authority's possession through a tribal land assignment. So there's a subtle distinction of when the housing authority does need a lease. And if you have questions on that specific purpose under the new or provision of the new leasing regulations, we encourage you to talk with your local agency realty officer. Let's go to the next slide. One of the most significant changes in the new leasing regulations came out of the consultation process. We heard consistently from the Indian communities that they wanted some accountability from Bureau of Indian Affairs. And so in response, we had some very specific deadlines put into the new leasing regulations. And you can see on this slide, we've identified the lease types to include residential, business, and wind solar resource leases. And then we also have the wind energy evaluation lease. And then we break it down between the lease, the amendment, the assignment, the sublease, and the leasehold mortgage. And you can see the corresponding regulations that establish the deadline. So for example, under a residential lease, the Bureau of Indian Affairs has 30 days to approve or state why we're not approving that lease. If we don't approve the lease or state why we're not approving the lease, the applicant can file a notice to compel action against the Bureau of Indian Affairs. And the 30-day timeline holds true for the amendments, the assignments, and the sublease. And you can see under the leasehold mortgage, it's a 20-day timeline. So I'm going to use as another example the residential amendment. Here we have 30 days to either approve or state the reason we're not approving an amendment. But the distinction here is that if we don't take action within that 30 days, then that amendment is deemed approved. So this compels the department to, one, monitor and track, and that's something we're working on here in central office. We want to monitor and track to see if we're meeting the regulatory timelines. But it also gives some flexibility to the landowners and applicants in getting their leases approved within a timely and reasonable manner. So those are the two issues, HEARTH Act and the new leasing regulations, and I think on the next slide we're going to open it up for questions.
Okay, thank you, Matthew. Thank you for your presentation. We've received quite a few questions that you all have typed in your question boxes, so we'll go over those right now. The first question is from Leo, and the question is, when will guidance be issued by the BIA Central Office to the BIA Regional Offices for implementation of the HEARTH Act? And Matthew, I'll throw that one to you.
We have issued a national policy memo, and let me look at the date of this. We did provide guidance, and it was effective January 16th, 2013, and this came from the Office of the Director of the Bureau of Indian Affairs. If you don't have access to this national policy memorandum, you can check at your local agency or email me directly, and I will share the policy memorandum with you. And that provides, I think, about a 7-page. It's about a 7-page guidance document. 8 pages.
Okay, thank you, Matthew. And the next question is there a template available for tribal leasing regulations? And Matthew, I'll throw that to you, but Karis, if you'd like to answer as well, you may do that as well.
We don't have a template. One of the things that we wanted to ensure was that tribes had, that we gave great deference to tribes on how they wanted to establish their leasing regulations. That said, we have taken the position that when the BIA, when the Secretary approves the leasing regulations, they become public record. So we have shared, after discussions with Drayton and Sandia, once approved, we shared the final document with other tribes that are interested in developing their own leasing regulations. So we have them available either through the local agency, the regional office, or here in central office if you need a sample. I believe the nation publishes their regulations online. And in fact, we looked at the nation's regulations as the model when we started working on the HEARTH Act.
Oh, and for Navajo, we do have our tribal regulations. It's on our Navajo Nation Division of Economic Development. They have it on their website, but I will be happy to email it to anyone. I think my email address, I'm not sure if my email address was provided, but I mean, our Navajo Nation leasing regulations are for public record.
Okay, thank you. The next question is from Michael, and his question is, buildings here on individual and trust land are being taxed by the county. What will BIA do to enforce the tax provisions of the newly amended 162 regulations? And Matthew, this one's for you.
We really don't have a plan of action for enforcement. Our direction here from the Solicitor's Office is that, one, we wanted to have an affirmative statement that gave tribes the ability to, or some leverage in arguing that localities and states don't have the authority to tax improvements on trust land. So on that note, there is no enforcement provision, but we would encourage you to speak with your in-house or outside counsel, and specifically legal counsel that specializes in tax law.
Okay. Thank you, Matthew. Karis, I was wondering if you could tell us a little bit more about some of the challenges that Navajo Nation faced in developing its environmental review process, and how Navajo Nation overcame those challenges. If you have anything in mind, if you could just expound on that a little bit, we appreciate it.
On the environmental review process, the challenges we did face was, well, the first one was whether or not NEPA applied, and there was some debate about whether or not that occurred because it was a federal delegation basically exercising federal authority. But we ended up taking, through that process, we ended up determining that there really wasn't any carrying out of any federal authority. There wasn't any federal action as defined by NEPA. And so after we got over that first barrier that the NEPA didn't apply, the next part was really trying to establish within the Navajo Nation an office that could carry out this function. Because we've always, no matter what project we do, we always had to follow the NEPA process, and we always relied on DIA to provide those clearances for us. So we had to develop within the Navajo Nation our Office of Environmental Review that would take on this new process, because it's not a process that mirrors NEPA. It's a process that incorporates already existing Navajo Nation law within the new regulations. And so we had to create a new process, which we hired 2 technical advisors to establish that for us, and be able to create the forms and the documents we needed to have to show what the clearances were, and establish sort of a standard process that our offices could follow. It was really difficult because they have to follow really 2 processes now. One under NEPA, and then one that they follow under the Navajo Nation Business Leasing Regulations. So, one of the things, it was just essentially just creating some offices and creating a process internally within the Navajo Nation to be able to carry out this new process, because it is substantially different than NEPA, and that's what we want it to be. We want it to be something that's modified to fit the tribe. So. Those are probably some of it took us a while to get all of that organized and coordinated, but now that we've been doing it for so long, 6 years now, 7 years, we have a pretty standard process now.
And this is Matthew. I want to add to that a bit. Many tribes do have their own environmental review process already established, but if a tribe doesn't have an environmental review process in place, the Bureau of Indian Affairs is tasked with assisting with developing that process. So that's still available to tribes, particularly for tribes that are considering having their own leasing authority under the HEARTH Act. The HEARTH Act is pretty straightforward on this, and it simply requires that the tribe provide for identification and evaluation of significant effects on the environment, and then provide for public notice and comment relating to the significant effects on the environment, and for the tribe to respond to the relevant comments prior to approving the lease, and then it allows the tribe to define who the public is. So if tribe is considering the HEARTH Act, and you have an environmental review process in place, oftentimes the leasing regs can be a simple deferral to the tribe's existing environmental review process. But if you don't have an environmental review process, you can either contact central office or more likely the regional office, and they will be tasked with assisting the tribe with coming up with an environmental review process. Were there any other questions?
Hello?
Hello, everyone.
Matthew, Karis, can you hear us?
Yeah.
I can hear you.
Okay. Sorry about that. We had momentary technical difficulties, but I think we got it figured out. Were you finished with your statement, Matthew?
I was.
Okay. Sorry about that. Our next question is from Ted, and we are actually going to unmute you, Ted. If you're ready to ask your question verbally, you may do so. We're unmuting your line right now. And we'll wait a couple of seconds if you want to get to your microphone.
Can you hear me?
Yes.
Great. My question is from the perspective of a federal lender. I work for USDA Rural Development, and I wondered what advice you have for federal lenders and non-federal banking institutions that might be interested in financing deals, projects on trust land, so that we all can keep pace with both the regulation implementation and HEARTH Act implementation.
And Matthew or Karis, either one of you, if whoever would like to answer that.
Go ahead, Matthew.
I was going to say, go ahead, Karis. So, Ted, help me better understand your question. Could you?
Well, it's kind of, let me preface my question with an offer. As a federal lender, we obviously have a trust responsibility to tribal members, and we want to make sure that our programs are implemented well on tribal trust land. But we have staff all around the country, just like the Bureau does. So I'm hopeful that in the coming months, not only Rural Development, but Veterans Affairs, HUD, and other lenders that have, I'm speaking primarily housing, but any sort of financing program on trust land, that we can train together with your staff so that we know which tribes are approved. We know how to work with your staff locally to help facilitate those actual homeownership transactions or business transactions, stuff like that. Okay.
I think there's a couple of options, and if we're talking about tribes that have their own leasing regulations under the HEARTH Act, you certainly can submit an email to me, and I can share with you who has approved regulations and who has regulations pending approval here in central office. If you want to work closely with the folks out in the field, as everybody knows, with the current budgetary climate, we're seeing some reductions in staff within the Bureau of Indian Affairs. But that aside, we can have you contact the respective regional realty officers. One of the other things that we're doing here in the Bureau of Indian Affairs with the budget reductions is we are transitioning our learning and development methodology from face-to-face training to training such as what we're doing today. We're doing webinars. So if there's an opportunity to partner with USDA or other federal agencies, that's certainly something that we're open to, and you're welcome to contact me directly, and we'll see what we can do to make sure your needs are being met. I don't know if that answered your question or not, did.
And hi, Karis, did you have anything to add to that?
I can add a little bit. We do have, we do get federal funding for projects on the Navajo Nation through, I think it's the EDA, Economic Development Administration. And so we do know that there's still some federal requirements that come with that, and our regulations accommodate that. It's just working out the details and the technical requirements with the Navajo Nation. So we do. It's not something that would prohibit or take away something that you have to still comply with. So we do still have many projects on the Navajo Nation that we do work with federal agencies.
Okay, thank you, Karis. Our next question is from Catherine, and we're going to unmute her line as well. So Catherine, if you'd like to ask your question, you may do so now, and we'll give you a couple seconds to get to your microphone. Catherine, are you there? Okay, so I guess Catherine's not available, so we're going to move on to Deborah. Deborah, if you would like to ask your question, we'll unmute your line, and you'll be able to do so right now. And we'll give you a couple of seconds as well. Okay, I guess Deborah's not available either. So we'll finally we will unmute Elizabeth. If you would like to ask your question, you are unmuted right now, so you can go ahead and ask.
Okay, yes, I'm here. Can you hear me?
Yes, we can hear you.
Hi, yes, my name is Elizabeth, and my question is regarding wind and solar leasing. And our tribe, my question is as a lessor, it's a tribally owned LLC that was established by the tribe, and we are leasing to a subsidiary, which is it's technically a state corporation that was established by the tribe, but it was established so we could get some of the tax, tax benefits. But it's wholly owned by a subsidiary of the tribe. So I was wondering, are any of the requirements waived because it's basically a tribe-to-tribe lease?
Requirements with regard to the new leasing regulations?
Yes.
The new leasing regulations give great deference to tribes, and so I would encourage you to read through the wind and solar resource leases, leasing regulations, and I think you'll find that under the new leasing regulations, things like fair market consideration, appraisals, the tribes aren't held to the same standard as what the old leasing regulations had. So while it's not exactly a waiver, when you read through the regulations, you'll see that a lot of the former requirements are no longer in the new leasing regulations. And that's typically specific to tribes because we did want to ensure the tribes had a lot more latitude than they did under the old leasing regulations.
Okay, thank you, Matthew. Our next question is from Glenn. And Glenn, we're unmuting your line right now if you'd like to ask your question. Glenn, are you there? Okay, I guess Glenn is not available. Okay, so we're actually now going to...
This question is for Karis. Karis, is there a separate process for leases to tribal enterprises who sublease to others?
For the Navajo Nation, yes, there is a separate process for tribal enterprises. Tribal enterprises are owned by the Navajo Nation, so we don't really, it's essentially leasing to yourself because they're part of you. So we have a mechanism that allows for tribal enterprises, depending on who they are. There's some tribal enterprises that need a lease for certain collateral financing purposes. So for example, with our Navajo Nation shopping centers, we've given them the ability to, because that's a type of business, the lease, subleasing, landlord-tenant relationships. And so we have a pre-authorization process that allows for the shopping centers to get pre-approval by the Navajo Nation so they can issue these subleases without further approval by the nation. The only part of that process that they have to come back to work with the tribe is, of course, for the recording process. The enterprise can issue its own sublease, but then it still has to be recorded, so it does have to come back to the Navajo Nation for that process. But yeah, we do have different processes for our tribal enterprises, and a lot of it just depends on what the enterprise needs from the Navajo Nation.
Thank you, Karis. Another question is, you spoke a little bit before about making sure that the leasing regulations are somewhat flexible that the tribe creates. I was just wondering, Karis, if you could tell us a little bit about, I know you spoke before about there was a bit of a challenge in easing the uncertainty that some outside businesses have going through the tribal leasing regulation process as opposed to the old BIA one. If you could just talk a little bit about how, what kind of challenges Navajo face with that and how they were able to address those challenges.
I That's a good question, because that was actually the issue that Navajo Nation faced. I think it's in its second year, and almost determining not to give this authority back to the BIA. When you're dealing with businesses, part of that, especially when you're dealing with the banks, financial institutions, and even when you're dealing with insurance companies and bonding companies, they don't like high risk. And one of the issues we had is when we took on this authority, we had investors and financial institutions who were not familiar with what the Navajo Nation process was. What kind of standards we're going to follow. There was a lot of uncertainty with this change of authority, and while the BIA process might have been lengthier and somewhat seemed difficult, there was assurances as to what that process was and what those requirements were and what protections these financial institutions and businesses would have with respect to sort of authority on the property and how the nation would how they're being treated, I guess, or and so we had some difficulties with trying to have these different entities feel comfortable with the Navajo Nation. And a lot of it just took a lot of education, just meetings with these industries, attorneys, with their chief financial officers, and having them feel comfortable with the Navajo Nation. A lot of businesses and a lot of these industries actually didn't come on to the Navajo Nation or agree to allow businesses or want to be under the Navajo Nation until they started seeing other industries come under the Navajo Nation. That's where our tribal enterprises really became important, because we have some, like we have NAPI, Navajo Agriculture Products Industry, and we have our Navajo Nation shopping centers and our Navajo Nation Oil and Gas Company. All of those started coming under the Navajo Nation, giving somewhat of assurances to these outside industries that the Navajo Nation process is stable, that it's a good process, that there's still some remedies out there. There's still it's not something that's uncertain, that we have a set process in place that requires council approval if we should deviate from it. So we had to put a lot of safeguards in there to make some of these outside industries feel comfortable with one, insuring our businesses, providing investment opportunities and financing for our businesses. So those are some of the challenges we faced, and it just took, to be honest, it took time. A lot of education and time, and then start bringing in some large businesses. And the first business, at least, that we issued under our regulations was to Raytheon, which is a large company. I think they're located out of Boston, and they were actually our first lessee. And bringing in more industries like that in our enterprises, really stepping up to the plate for us, gave a lot of comfort to these outside investors and outside industries that our process was stable, and they were willing to come under and be governed by our regulations. So we don't have those issues that much anymore today, because we've been doing it for so long, and people are seeing how flexible our system is and how business friendly our process is. So we have a lot of industries now that are wanting to to come and work with the Navajo Nation.
Okay, thank you, Karis. We've been getting a lot of questions about if we're going to make this presentation available, and I just want to mention to everyone that we will send out an email to everyone that registered for the webinar. We're going to send the PowerPoint slides, and we will also send a link to the presentation in the email as well. So I just wanted to make quick mention of that. And now our next question is going to be from Deborah. And Deborah,
yes.
We're going to unmute your line as well.
Thank you. Am I on?
Yes.
Hello? Oh, great. Thank you. A lot of what was said answered some of my questions. I represent Blackfeet. I'm an attorney in Seattle. We represent a lot of tribes in business beyond gaming. I guess with the HEARTH Act and what my question is, and some of it has been answered to some degree, is the concerns where we do debt financing with tribes, where we look to work with tribes so they can issue debt into the marketplace, but that requires some kind of public component to get the tax-exempt financing. So I'm wondering if this has been a problem, or can you foresee any, or have you had any, when tribes either put up their own business, or they have a tribal entity that's their business, or any kind of business where there may be or could be some kind of exclusion from the public. And I'm wondering, I mean, that could be anything from a tribal gym, church, community center. And I know that you defined public before, but that was for notice. So I'm wondering if this, or is it just too early to tell?
This is Matthew. From my perspective, it's too early to tell.
Okay.
We haven't gained enough experience. I don't know if the nation has had any experience in this, so I'll defer to Karis.
Actually, no. We haven't hit that issue yet. We've been doing this for a long time, and we haven't run into that issue as of today.
Thank you.
So let me ask a question: is the concern that the lender would not use the leasehold approved by the tribe as collateral for the loan? Is that?
If the tribe were to issue tax-exempt bonds, the lender would require, as does the tax-exempt bonds for tribes, like any other municipality, that it have a public component. That is, it's a, whatever they call essential good or whatever, essential governmental use or something. And if you don't have that public component, then you can't issue tax-exempt bonds, though we do go around, obviously, the essential governmental services requirement under the IRS. Maybe I'm just getting a little bit ahead of myself. And I guess what I'm mainly looking at is when a tribe it's a tribal entity, not Raytheon or, you know, McDonald's or anything like that, where you definitely want public there because it's business. I'm talking about when a tribe itself is like having something that is exclusive or mainly for the benefit of tribal members.
So is the question whether or not the tribe can approve those leases under the HEARTH Act? Is that where we're...
Well, I'm sure they can. I guess what I'm concerned about the next step is whether or not it would hinder financing and lenders. And maybe
we haven't experienced that. That's not to say that it couldn't, but you know, I think we're a couple of months into the process, so we haven't had that experience as of yet.
Thank you.
Thanks.
Okay, thank you, Karis and Matthew. Our next question is from April. And April, we're unmuting your line right now if you'd like to ask your question. Okay, April is not available. We'll move on. And the next question is from Elizabeth. And Elizabeth, if you'd like to ask your question, we are unmuting your line right now. Elizabeth, are you there? Okay, I guess Elizabeth is not available as well. So that concludes our Q&A session. Those are all the questions we had. And I'd just like to thank you all again for joining us today. Karis and Matthew, thanks to you both. You both did a wonderful job in your presentations and also in the question and answer session. And I just want to mention again, we'll definitely have this presentation available. We'll send out emails with the PowerPoint presentation as well as a link to the presentation that you can hear again and view again. And yeah, thanks everyone, and have a good evening. Thank you.
Thank you.